and very happy to have this event tonight with John Quebeca, Director of the Silicon Valley Office of the U.S. Patent and Trademark Office. John has carried out strategic direction of the Undersecretary of Commerce for Intellectual Property. A lot of other stuff here, but I think we really should get right into this presentation. So I think we'll just go directly to it. We're ready to go there, Ken? John is a 25-year veteran of the U.S. Patent and Trademark Office. He most recently served as the Senior Advisor to the Undersecretary of Commerce for Intellectual Property and Director of the USPTO. In this role, he oversaw the staff of the Office of the Undersecretary and will work closely with fellow members of the USPTO's Executive Committee to implement the policies and priorities for the agency. So John's talk tonight is titled The USPTO in Silicon Valley, Opportunities for Engineers and Inventors. John.
Thank you.
Thank you.
Okay, good.
Make sure you're all
I thought I was.
Yeah.
Can you hear me now? Am I allowed to say that? All right. All right, good evening, everyone, and thank you very much for the introduction. And it's an absolute pleasure to be here today. One of the things that, being an electrical engineer myself, I feel like I'm with my peeps. Usually I'm with, not that there's no attorneys in the room. Actually, how many attorneys are in the room? Just curious. So, okay, good handful of attorneys. Usually it's the other way around, so I'm definitely in the minority, especially after being at the Patent and Trademark Office for 26 years. Usually surrounded by attorneys. So very happy to be surrounded by engineers tonight. And thank you for coming. What I thought I would cover today is a few things. Because I'm not exactly sure, what the foundation is of everyone's knowledge with respect to the U.S. Patent and Trademark Office, and particularly with protecting your intellectual property, I thought I'd spend a few minutes talking about, just at a high level, the different types of IP, and then go into, again, at a very high level, the patent process. Don't worry, I'm not going to make anyone file a patent application today or anything along those lines. And I'd like to segue that into the patent examination process, and then talk about a few programs that we have that are designed to encourage stakeholders to interact more with our patent examiners and with the patent examining workforce. And then I'll close with two things. I'll give you an overview of the Silicon Valley USPTO and the types of services that we'll be bringing to the region through our satellite office that will be opening later this year. And then also close with some resources that you might find helpful. I believe this presentation will be sent to you after the meeting. So if we get time to go through them, great. If not, they'll be there for your leisure at a later date. Oh, the other thing I just want to highlight quickly is I was very pleased to see that through the registration process that the registrants could submit questions, and we will definitely be getting in touch with those that wanted to hear from us. But at the same time, it helped identify some of the things that I'll be capstoning tonight as well. Okay, so general overview of intellectual property. So we have patents, two types, utility patents, design patents. We have plants as well. Copyrights, trade secrets, and trademarks. So, so how many people already know all this? So all right, okay, good. So, all right, I'll go through it quickly. So I like to use I usually have a prop, so pretend this is a Coca-Cola bottle. Because Coca-Cola, I think, is a prime example of all of these different types of intellectual property. For trade secrets, everyone knows that the formula for Coke is well guarded and cannot be, no one person knows what that, you need it higher? Is that better? How's that? Is that better? Okay. Oh, okay. So, trade secrets, we know Coca-Cola's formula is protected. No one person really knows what the formula is. Trademarks, I think that as a result of Coca-Cola's trademarks, they are one of, if not the most widely recognized good or service in the world. Copyrights, protect a actually work of art, books, photos, printed publications, computer programs, things like that. And in the Coca-Cola example, it could be copyrights are used to protect their jingles or slogans, things along those lines. Design patents, the shape of the Coca-Cola bottle, whether it has the red label on it or not, you immediately recognize it just by the shape, and that's what design patents do. They protect the ornamental features. And then the utility patent, a variety of utility patents around the Coca-Cola product with respect to the bottling process, how the plastic is extruded into the specific shapes, how the conveyor systems work on the manufacturing plants, a variety of different things to highlight utility patents which really protect the use of your inventions. So like I said, I was going to go through that very quickly, but being the fact that I've been at the Patent and Trademark Office for 26 years now, I see patents in absolutely everything. So if you ever walk down the street with me or you're shopping, you'll just see me point things out and go, that's a patent, that's a patent, that's a patent. And I can do that in this room, but in the interest of time, I won't. But just taking a simple cell phone, which has thousands of patents associated with it, the key feature here, the key focus I'd like to leave you with, is that many products, much like the Coca-Cola example, need to take into consideration their IP strategy. And it might not just be a patenting strategy, it might not just be trademarks, trade secrets, copyrights, or designs. It may be a combination of all of these things. So as we're innovating and thinking of ways to protect our innovations, we need to think about the entire IP system holistically. So what is a patent? A patent is the right to exclude others from making, using, selling, offering for sale, or importing their claimed invention. And I like to compare this to trademarks, whereas in order to get a trademark registered, you actually have to demonstrate use of that mark in the marketplace and in commerce, whereas the patent system is designed to give the patent holder the right to exclude others from making and using the device. Patents are a limited term. We'll talk a little bit more about that. And a patent in the US is only going to protect you in the US. So if you were going to explore other avenues in other countries, you would need to protect your innovations in those countries as well. So the patent system is a quid pro quo system. So in return for giving a limited right term to an inventor of this right to exclude, we publish your invention. So one of the requirements to get a patent is you have to tell the world, so that someone skilled in that field of technology should be able to read your disclosure and make and use your invention. And the reason we do that is to accelerate innovation through the publication of that innovation. Yes, you're telling the world what you have protection for, and at the same time, your competitors are looking at your products and thinking, okay, well, how can I innovate around that? So that spurs competition, it helps create jobs, and I think it does help advance technology and advance the growth and strength of our national economy. All right, so patents have a lot of value. They can be used to gain entry into a market. They can be used as collateral. They can be used in a defensive posture, and they create revenue. So it's one of the things that we've heard when we've talked to venture capitalists is, and I believe there was a study out recently that said venture capitalists tend to give about 30% more funding to those that have patent protection than those that don't. And so especially for startups, and this is kind of an overlying focus for this evening, is this IP strategy is a business strategy, and recognizing the fact that small businesses and independent inventors really struggle with every dollar they make in trying to make what's the best use for this next dollar, and to help advance their business. And our goal is to make sure that they understand what the IP system does for them and does for the economy, and at the same time making sure that incorporating an IP strategy into their business strategy is essential. Right, so this is the easy path to a patent, and for those of you that have been through it, recognize that this is very elementary. So from an idea, there's two options. You can go to a provisional application, which just, it's just the disclosure of the invention. It's but the disclosure has to be an enabling disclosure to enable someone skilled in the technology to be able to read that disclosure and make and use the invention. Even though we don't publish the provisional application, it still needs to meet that stringent disclosure requirement. One thing that's nice about a provisional application is that's all that's required: disclosure, drawings associated with the disclosure, a form, and the fee. And so what that's designed to do for very low cost, for micro entities, which we'll talk a little bit about, it's only $65, and for small businesses, it's $130. But what it does is it gives you a one-year period with which to perfect the filing of your much more complex non-provisional patent application. And the non-provisional patent application, if filed within a year of the provisional application, will be treated as if it was filed on the filing date of the provisional application. So it's actually a way to extend your patent term by a year by taking advantage of the provisional application prior to the non-provisional. Especially now that we are transitioned to a first inventor to file system, it's equally as important because you can get your filing date set, patent pending status right away, and then spend the rest of that year perfecting the filing of the non-provisional application, getting your claims in order, you know, perhaps working with your patent attorney, and getting ready to submit that application to the patent office for examination. So that's the simple one as far as the patent system, but once you have a patent, there's a lot of other things that come into play. And this is just, you know, a snapshot, and by no means meant to be all-inclusive, but of what else is part of the cycle of innovation. So, and they're not in any particular order, and you don't necessarily have to go through or experience every single one of these. But at the same time, this is, many companies follow this route. So after the patent's granted, you know, there's certainly some marketing, some licensing, commercialization. You want to generate revenue, you want to create more jobs. The competition is hot on their tails, you know, looking at your patents, trying to innovate around your disclosure, or perhaps getting in touch with you to generate, to engage in a licensing agreement or something along those lines. You know, the patent gives you the ability to enforce your rights and perhaps you know, take parties into litigation. And at the same time, you know, the whole quid pro quo system is designed to create follow-on innovations and start the cycle over through research and development and creating new ideas and filing new patents and so on. So it is a cyclical process. So just real quickly, anyone may apply for a patent, with one exception. Does anyone know who the exception is? So, no, you can file a patent.
President of the U.S.
So, only exception is officers and employees of the U.S. Patent and Trademark Office. So which makes sense, right? So we do waive our right to patent, and it's funny because, you know, as a patent examiner, I'm sorry.
Do you get your rights back?
So yes, there's a term with which you have to wait, and then you can file patent applications. So, but being a patent examiner and working with applicants, you're always thinking, you know, you understand the technology you're working in very well, you're trying to identify the claim scope, and it does make you think very innovatively and creatively, so it makes sense that this is a bar on us, I have to say. So when I come up with things myself, I just offer them freely to people, since I can't do anything with it. So one thing I tell patent examiners is their job is easy. All they have to do is make sure that every application they review is, the claims are new, non-obvious, useful, and clearly described. It's just that simple. And if anyone has seen the Manual of Patent Examining Procedure, I think it's somewhere around 3,000 pages now, but those 3,000 pages will tell you how to make sure those 4 things are done correctly. Right. So I just want to turn, so we talked about the disclosure and how the disclosure has to be enabling and so that someone skilled in that technology can make and use the invention. But the real crux of the patent lies in the claims. And the claims are where there's a specific definition of the invention and where the metes and bounds of the patent coverage are actually set forth. So one thing that I feel very strongly about is it's very easy to get a patent, regardless of what you've heard. All you have to do is pack so many details into it and make sure that the claim is so specific that it would be difficult for the examiner to make an adequate rejection, and they would issue the claims. And at the same time, it will be extremely easy for any competitor to be able to innovate around your claims because they're so narrow. So the more specific the claims are, the less valuable they are, and the more broad that they are, the less patentable they are. And so one of the reasons we constantly recommend that patent applicants seek the counsel of a registered practitioner is because they would understand that sweet spot and how to get claims that are not too broad and not too general and not too specific, just right. So the Goldilocks, right? So here's just to give you a sense of a very high level of what a claim does. So the scope of the claim with every limitation gets narrowed. So if I have a housing with an opening to receive a memory storage device, where in the memory storage device is an optical disc, each one of those limitations narrow that claim further. And what it also does for the patent examiner is it narrows their field of prior art. So when it was just a housing, it could be anything with the housing. And with an opening, and so I have a suitcase as a ridiculous example, but suitcase is a housing with an opening. To receive a memory storage device, I can open the suitcase, throw a memory storage device in there and close it. Is that reasonable? So the examiners, when they examine claims, are supposed to apply what's known as the broadest reasonable interpretation. So when we get down to, okay, we're in the storage device as an optical disc, okay, well maybe that is a laptop. I'm sure there are tons of other examples as well. Suitcase might be a stretch, and that's where the examiner's judgment comes in. And it might just be a signal to the applicant, well, gee, your claims are just too broad, and you need to narrow them further. Just checking time. Okay. So with that, since we're talking about patent examiners, I thought I would just give a brief overview of what patent examiners do. So their job is to read and understand your specification, to determine whether it's adequate and enabling, for one that's skilled in the art to make and use the invention. Their job is to determine this claim scope and to map out those claims, and then to search existing technologies for that claimed invention. And then based on their findings, they'll determine patentability. They'll write office actions back and forth between the applicants, and they'll respond to applicants' response. And ultimately, every patent application that is filed before the USPTO will either be issued and granted as a US patent or abandoned. And that said, one thing that I like to highlight, especially in the past several years, is we have really transitioned our agency to be one that is focused and dedicated on engaging with the patent applicant. So at any time throughout this process as a patent applicant, you should feel more than comfortable calling the examiner and talking through your issues in an examiner interview. We've provided a lot of training to patent examiners in recent years. We have a lot of virtual tools to enable examiners working around the country to be able to participate actively with applicants, and we'll talk a little bit more about that when we talk about the services offered through the regional office. But just again to focus that we're very proud of our hardworking examining workforce, and whether any of you would like to become a patent examiner or not, we are actually opening up our Silicon Valley office later this year and expect to have, in the first year of operation, 80 patent examiners hired, primarily, initially anyway, in the electrical engineering, computer engineering, and mechanical engineering areas. There are a few other disciplines that get folded into that as well. But if you are interested, we believe our vacancy announcement should be posted sometime within the next week or two. And hoping to bring our first class of examiners on later this fall. But whether you choose to follow in my footsteps and serve in a career at the U.S. Patent and Trademark Office, I think awareness of the law for engineers and an understanding of patents and the patent system and how it works is critically important, particularly since we've transitioned to a first-to-file system. In the past, we had a first-to-invent system. We would go through great lengths to figure out who the first inventor was, regardless of when the application was filed. That is no longer the case. So it is important to protect yourselves and protect yourselves early to avoid getting wrapped up in the first inventor to file issues. And again, patents, do give you a defensive posture. It gives you a lot of leverage when going out and trying to get funding or trying to find someone to manufacture your invention. It does protect you in so many ways. So just as a quick highlight there, for patent examiners, you must be a citizen and be willing to relocate to either Washington, D.C. or to one of the satellite offices. Fortunately, we have one opening in our backyard in just a few months. So just to highlight some of the skills that patent examiners possess is they really require excellent common sense. Examiners have to also be able to visualize the inventions and take a step back when they look at a claim and say, okay, well, I understand the invention, I understand the claim, but what else is really being covered by this claim? Is the claim so broad that it's overlapping other technologies, and maybe I need to go look there as well? So they really do think in an applied way. They're much more practical than theoretical, and they love talking about technology, and that's one of the, I think, best things about being a patent examiner. We're constantly, whether we're with our colleague next door or with a colleague working from home a couple thousand miles away, we are constantly engaging with our fellow examiners in asking their advice, and it's a very collegial atmosphere, and I think that's one of the most rewarding pieces for me. Memory for details, I would say I've never really had that, but so far it's worked for me. Some details, yes, it just depends. And then it really is truly an environment of continual learning, and I want to talk a little bit more about that. But before I do, the patent examiner job, one of the things that's actually really nice about it is structured. You know exactly what you need to do in order to succeed, and you have all the support there with you at the USPTO to help you succeed. Because it is so collegial, there's no competition as a patent examiner between you and your fellow colleagues, so there is this truly culture of just trying to help each other do the best job we can. So, and to prove that, the past several years, in 2007, the USPTO was the 172nd best place to work in the federal government. And so, and in 2013, we were the #1 best place to work in the federal government. And thank you. And it goes to show, even in 2014, while we're now ranked, so that's the ranking that carried us into 2015, we're ranked #2, but we've increased in every single one of our metrics that are, this is a survey that is administered through a nonprofit organization in Washington, D.C., called the Partnership for Public Service, and they administer this survey across all the federal government to all employees every year. And we're just so proud of our achievements, but if you ask any one of us, how did we get there, every single one of us will point to our employees. And we got there from 172nd to the top 5, and by listening to our employees, by being responsive to their needs, making sure they had the tools and the resources that they needed to succeed. and we've become a much more engaged workforce as a result of that. And hopefully that's something that you've seen if you've been prosecuting patent applications before the USPTO for many years. You should have seen a continual improvement. So just some nice benefits about being a patent examiner. So here's my last slide on the plug for being a patent examiner. We provide a slew of technical training. You know, the first, if you have no IP experience and you come to the work at the USPTO, it's a 4-month training class just for starters. If you have IP experience, we usually start with 5 weeks and then figure out what else to build on from there. But even once you're out of the academy, you always have mentors and your supervisors and primary examiners to rely on to help you succeed. And we provide continuous legal training as well as technical training to our patent examiners every year and throughout the year. But we do also offer very flexible work schedules and alternative work schedules for our examiners by that I mean through teleworking opportunities, where examiners can, after a certain time and meeting certain criteria, and they actually have to pass a certification exam, are allowed to work from home full-time, or almost full-time, regardless of where in the country they may wish to live. And so that's been one of our largest culture changes at the USPTO, and we've come a long way in making sure that our employees are as engaged when they're working from home or as they are when they're working next door. And so again, just very proud of all of their efforts in making sure that our expansion nationally through our telework programs is one that has, while there continues to be lessons learned, one that we're continually proud of. So we are a continuously growing organization. Last year, in the past several years, we were hiring 1,000, 1,500 examiners per year. We've brought our workforce now up to 8,500 patent examiners. And again, it's kind of a caveat to why we're starting our regional offices is, you know, getting that many patent examiners to come work and move to Washington, D.C. and work out of our headquarters in Alexandria is, we're successful every year and very pleased with our workforce, but we're also very energized by the fact that we'll be tapping into a new pool of candidates by hiring out in the Silicon Valley and through the other regional offices. Okay, so I mentioned we provide a lot of legal training. So this is, I believe, just the past 2 years of the legal training that we've provided to all of our patent examiners. And this is available on the website. For those of you that have been following some recent Supreme Court decisions, those guidelines are up here as well. And along with examples of what we consider to be statutory examples and what we consider to be non-statutory examples. And we are continuing to update our training site for the public. And every time we finish rolling out training to patent examiners, regardless of what that training is, we post it on the website for the public to view and to also see the computer-based training that's been provided. But in addition to legal training, we also provide examiners with technical training. And we do that in-house, and we do that through some procurements. But one of the most successful ones is by reaching out to all of you and asking the scientists and engineers that are in the field, especially in these complex and emerging technologies, to help the USPTO by sharing their expertise with our patent examiners through the Patent Examiner Technical Training Program. So this is where you can volunteer your time, and we can connect you with patent examiners working either out of a regional office, or whether they're working out of the regional office where you'll be presenting, or out of headquarters, or from their home. We will ensure that all examiners working on technology related to that topic will be connected to hear your lecture. So if that is something that you're interested in doing, I have pamphlets in the back of the room, and but also refer you to our website. All you have to do is from uspto.gov is just type in PETTP or Patent Examiner Technical Training, and it'll take you right to the site. So last year alone, through the expansion of our Patent Examiner Technical Training Program, we doubled the number of training modules that were presented to, that were offered to patent examiners, and tripled the number of time examiners spent in technical training. Again, it's an increased focus and one that we continue to want to support and engage with our stakeholder community to help us make sure that we're up to speed on these emerging technologies. And it does, and I say emerging technologies, but last year I think we had lectures on golf balls all the way up to complex pharmaceutical devices and biomedical devices, as well as cryptography. I mean, just covering the gamut of the technologies that we see before us every day at the USPTO. The other program is where instead of you come to us, we come to you. So this is the Site Experience Education Program, where patent examiners every few years or so are allowed to actually leave their offices or their homes and meet with stakeholders and meet with companies and corporations and inventors on the technologies related to the technologies they examine every day. And just to share a personal experience with you, the very first one I went on, I believe, was in 1994, and I don't want to say the name of the company, but it was a robotics company. And so what it really does was it opens the examiner's eyes to how important the decisions that they make every day are to the patent applicants. It really brings it home, and hopefully this example will illustrate why. So we were meeting with an inventor at this corporation, and I believe it was a heat sink, and he was demonstrating the heat sink and explaining to us all of its features, and at the end he turns to the group of us, and there was about 10 examiners in the room, and he says, well, wasn't it amazing how we were able to reduce the size, increase its performance, increase its overall efficiency, and reduce the cost of the product? And we're all like, yeah, that sounds great. And he says, okay, well, which one of you is John Quebeca? And I raised my hand. He goes, why did you reject my patent? So I granted it right away. No. It really does. I mean, but it helps to really bring home the passion that, and even speaking with some of you prior to the event tonight, I could really sense the passion in the room, how passionate you are about what you're working on, and giving the examiners that experience just translates directly to the quality of their work product. So we've expanded this program as well. And yes, the inventor ended up getting a patent, but not without a claim amendment. And and it is just a program that I'm very fond of, and I've enjoyed the 2 trips that I've been on in my career. And now in the West Coast office, I'm just very pleased to see host the examiners when they come from all over the country to headquarters, or to the Silicon Valley, to meet with stakeholders in the region. How am I doing on time? Okay, I'm pretty good still, I think. Okay, so now I thought I'd tell you a little bit more about why I'm here in the Silicon Valley office. And I did get a comment, I don't remember who said it earlier this evening, is, what took so long? And, I tried. So, I was on a budget modeling committee in the late 90s and proposed a satellite office in the Silicon Valley, and we actually got it into our budget, and being the budget process being as complex as it was, immediately gets stricken from the budget when they see how expensive it is to open a brick and mortar facility in the Silicon Valley. The same holds true with other satellite offices too, and we tried, and the question I get then is, well, what took so long? Why did it take 15, 16 years? And it really did take an act of Congress to mandate that the USPTO open satellite offices in strategic regions across the country. And we didn't open them because we had to. We've always wanted to, but now we're opening them because it made sense. And through the American Invents Act, which was signed in 2011, not only did the act direct the USPTO to open these, it did several other things. We went on a nationwide search to identify the specific locations where to open the Silicon Valley office, where to, I digress. So no, where to open the satellite offices, and we received 600 comments from municipalities across the country and from stakeholders across the country, vying for the USPTO to open up in their backyards. And I think that that was pretty telling. So we garnered the nationwide support that we needed to open these, which was also an issue that we faced in previous attempts. And then the other thing is that American Invents Act did was it gave us fee setting authority, which ensures that these brick and mortar facilities will not only remain operational, but fulfilling the goals of serving the needs of the communities and where they're located for the long term. And so again, we're just very pleased to have identified 4 offices. They said we should open 3, we decided to open 4. And we opened Detroit, Michigan, which was our first office. It's almost 3 years now. In June, it'll be 3 years since that permanent space has been open. Denver, Colorado moved into their permanent facility just last June. And the Silicon Valley and Dallas have been operating out of temporary quarters for about 2 years now. And the Silicon Valley's temporary quarters are in Menlo Park. We share space with the U.S. Geological Survey. And we are very excited to be moving into San Jose City Hall later this fall. And then right on the heels of that, Dallas will be following. And so hopefully by the end of the calendar year, assuming all goes well, that we will be moved into our permanent facilities. So one of the things that we made very sure of when we created the satellite offices and designed the programs, the satellite office program, is to make sure that each one of the satellite offices really take on a look and feel of the community where they're located. We didn't want them to be just mere cookie cutters of headquarters. We wanted them to make sure that they were not only serving the needs of the community, but also identifying and fitting into the innovation ecosystem. So in the Silicon Valley, it pretty much covers the gamut. We have startups, we have biotech, we have high tech, large companies, small companies, and so it really does cover the gamut of our stakeholders. Strong academic institutions, and similarly, the other offices, have other strengths as well. So they have, entrepreneurial vibe running through all of our satellite offices, and we have been working together as a series, as leaders of each of the regional offices, to create programs that not only meet the needs here, but that can also be tailored and tweaked to meet the needs of the other satellite offices as well.
So why are you still wearing a tie?
Because it's webcast. No. It's hot. I almost took it off. So, so here's the San Jose City Hall, if you haven't seen it. So there's the tower, the rotunda, and the 3-story wing on the right. And we will occupy most of that wing. And one of the things that I'm really excited about is the entire first floor is going to be dedicated to outreach and education for the community. So we'll have a series of walk-in services, as well as we'll also have the examiners training center on the first floor, but when we're not training patent examiners, we will be engaging and working with the innovation community at a variety of different levels. So just some examples of what we'll provide through the Outreach Center is we'll have walk-in services where you can obtain information about patents, trademarks. I already gave you the overview, so you already know everything there. We'll have workstations for searching patents and trademarks, and searching the trademark register, which is also available online, but you'll get assistance with how to search the trademark register. And as far as searching for patents, we'll actually have available the same search system that our patent examiners use to search through their patents every day. And that's only available through headquarters and through the regional offices. And we'll also provide assistance with how to use those tools as well. As I mentioned, we're tailoring our programs to the needs of the community, and we will have workshops, just-in-time training for IP professionals, especially as new rules and regulations are affected, and we'll have roundtable discussions. One thing that every satellite office will have is a hearing room where we'll administer patent trial and appeal board proceedings, so primarily through the trials, and then perhaps some ex parte appeals as well. And similarly, the Trademark Trial and Appeal Board will host some of their trials through the satellite offices as well. But one feature I'm particularly proud of is the virtual interview rooms that we're building in each of the satellite offices. And right now, you have several options. If the examiner is working within 50 miles of the USPTO or from one of the regional offices, you can do an in-person interview. Or you can do a telephonic interview, or you can set up a WebEx interview. And the WebEx interview, the examiner creates the WebEx, sends you the link. You can see the examiner on the screen. You operate from the examiner's desktop, and similarly, if you have a camera, the examiner is able to see you. But you spend most of your time directing the examiner where to go as to manipulating it, as far as manipulating the screen goes. So one of the things we're testing out right now in Denver, and we'll be incorporating them into the satellite office in Silicon Valley, is high-resolution document cameras in the interview rooms where you can actually demonstrate a feature of an invention or point to specific elements in a figure or in a specification or in a claim or do line items and have a much more interactive experience with an examiner through this virtual interview room. So we're testing it out right now in Denver. It's been going well. We've already planned the installations for headquarters, and when we open the Silicon Valley office, they will be operational there as well. So again, trying to step up that level of engagement. If we can't have an in-person interview with a patent examiner, then we want to make every effort we can to make the virtual experience as much like an in-person experience as possible. I mentioned the Patent Examiner Technical Training Program, and through our remote training capability, we can host scientists and engineers in our satellite office and then connect them to the examiners working in those technologies for that Patent Examiner Technical Training. One other thing I've been doing is working with other federal partners in the region that also have programs that are designed to support and foster the small business and entrepreneurial community. And we're working on building a more holistic programs through the outreach space in San Jose City Hall, where we can meet more of the needs of our small businesses. And so stay tuned for that. And one of the things that I'm looking forward to is they'll actually have office hours within our facility so that someone can come in and meet not just with the USPTO, but can meet with the Small Business Administration or with ITA. I won't spend too much time on this slide, but just to give you an example of some of the things we've done already, even without the permanent space. We've had several tech-specific partnership meetings. We did the first ever biotechnology partnership meeting that was held simultaneously on both coasts. And we just a couple of weeks ago did our second one in partnership with the Dallas office and headquarters. And so, and we also held our very first inaugural cyber technology partnership meeting that we've been working very closely with the cyber technology community, trying to address issues that intersect intellectual property and cybersecurity. And then over the past year and a half, we've held several software partnership meetings with software stakeholders in the region. We've held a series of international programs as well. In fact, just last week, 6 of our 9 IP attaches, which are located in strategic regions around the world where IP enforcement isn't as good as we think it should be, and they work very closely with the governments on the ground there to help them strengthen and step up their IP enforcement. And so I was joined with the IP attaches from Mexico, Brazil, Mexico, Brazil, India, Middle East, Russia, and China. And we met with a series of stakeholders on a variety of issues that they face every day. And again, trying to make sure that we're covering the gamut of intellectual property issues that we see out of headquarters, but bringing those services out to the West Coast. One thing I'm also very excited about is personalizing the outreach center at the USPTO, and being a long time proponent and working with independent inventors throughout most of my career, one of the things I have found most rewarding is that one-on-one experience that you get with an independent inventor. So we'll be building in time for stakeholders to come and meet for 15 or 20 minutes with a patent supervisor or myself to talk about what any questions you might have. Now granted, the USPTO can't give you advice, but we can give you assistance and help guide you on any direction you wish to take. So we'll be creating opportunities for you to sign up and for these one-on-one experiences while we're open in our outreach space. Okay. I'm going to skip this slide because I got the hands in the back and just go quickly through some of the resources that we offer to our stakeholders. For under-resourced stakeholders, we have 2 programs. One is our pro bono assistance program that we don't administer it, but we work with the different organizations in each of the states around the country to develop and strengthen their pro bono program. So in the state of California, the pro bono program is administered through the California Lawyers for the Arts, and it's the California Inventors Assistance Program. And again, you'll get copies of this slide deck, so you'll be able to have the links. But there are certain requirements to participate in the program, and then also not only are we looking for people to apply through the program, but also for IP professionals to volunteer their time and offer their services in cooperation with the California Inventors for the Arts, for the CIAP, California Inventors Assistance Program. And the California Pro Bono program is the largest in the country. It actually covers all the western states currently and has been extremely successful. It's actually been a model for other pro bono programs across the country to follow. And each pro bono organization has their own guidelines of what inventors need, how you need to qualify to be part of their pro bono program. So I just encourage you to reach out to them if you're interested. The other one is through our law school clinic program. And many law schools have their own law school clinics, but the USPTO administers a law school clinic certification program where students are given a temporary or provisional registration number, and then they work with a registered practitioner who actually signs off on all the work. And it's a good way to get law students up to speed on patent prosecution issues, and at the same time give them much needed experience when they enter the workforce, and at the same time being able to provide pro bono services to the applicants that are participating in the program. So again, many schools have them, but the USPTO has their certification program, which focuses primarily on both patents and trademarks. And here's a list of the schools that we have in California that are participating in the program. For those that have an invention but aren't really sure what to do with it, we have the IP assessment tool, which will ask you a series of questions. It does take a little bit of time to go through, but it is a good way to get familiar with and there's also some introductory training videos that you can take, but it's a good way to get a sense of what direction you may want to go. At the end of the survey, it'll say, oh, well, it looks like you have a trademark. You might want to look here, or you might want to decide between a design patent or a utility patent. Here are some more information for you. So it's really a way to help focus giving you information, and you highly recommend that one as well. We talked a little bit about this before, in the dialogue with you before we started this evening. Track 1, also a gift of the American Invents Act, is merely acceleration of your application for a fee. So for a large entity, it's $4,000. For a small entity, it's 50% of that, so $2,000. And if you qualify as a micro entity, it's 75% off, so it'd be $1,000. And what we're seeing is an average of 5 months from when the petition's granted to when the applications are allowed. So we're seeing very fast turnaround. Usually from petition grant to first office action is around 2 or 3 months. And Again, many who participate in track 1 are very engaged with the patent examiner and have examiner interviews and try to resolve issues early. So it's been hugely successful. It's capped at 10,000 applications a year. Last year we came close. So this year we're still trending similar to where we were last year, but it'll be interesting to see where we finish here and what we decide to do with the program, but hugely successful. I mentioned microentity status, so I thought I would throw that out there. That's where you can get 75% off of most of your patent fees. There is a requirement to qualify for microentity status. You have to certify that you have less than 500 employees, but that you have also not been named as an inventor on more than 4 previously filed patent applications, and you or someone who you may have assigned your application to, neither entity could have made more than 3 times the median household income for the nation. So if you want to know what that number is, I have links at the end of this. I think right now the 3 times number is, don't quote me. I'd be pulling a number out of the air right now. So I want to say it's like 60 something, right? 62, right? 162, okay. So 162, thank you. Okay, so that's microentity status. And then if you're ever at a point where you no longer qualify for microentity status, you have to ensure that the very next fee you pay is the appropriate fee. So it doesn't grandfather you into status if your status changes. So similarly with a small entity, as soon as you're no longer a small entity, meaning you have more than 500 employees, you need to start paying the large entity fees. So that's just one concern people have had with the program. Sure.
Like all the authors of the invention?
Yes.
Meaning everyone has to qualify?
Everyone has to meet that qualification. Yes. Yeah, that's the bottom bullet there. It has not assigned, granted, or conveyed to an entity that has earned more than 3 times the household median income. Okay, so that's microentity, but again, it was primarily designed to help reduce the burden on under-resourced inventors, and also been very pleased with the number of people that have been filing under that status. The last one I want to highlight is the Patents Ombudsman Program, and this is where if you have an application before the USPTO and your examiner, and you and the examiner don't see eye to eye, you should always, obviously try the examiner. If that's not working, try the supervisor. If there is an issue that you think is not being resolved, please contact the Patent Ombudsman. They are really the cream of the crop in every one of our 9 technology centers at the USPTO. Their job is to make sure the application gets on track, or at least you have a better understanding of why the examiner is taking the position that they are taking. It is and it's also non-punitive for the examiner, so it really is designed to help you get your application back on track. So if you haven't yet had to experience the ombudsman, have to reach the level of the ombudsman, hopefully that never happens, but if you do, they are there to help get you back on track. And it could be for a variety of different issues. And through the online form, you'll be able to see what the specific issues are, but primarily they're there to help you progress your application and get it back in the pipeline and moving. So here's the list of links. I'm not going to go through, but you'll have them in your materials. And with that, I will just say thank you, and I'm happy to take any questions. Yes. Oh, wait. Oh, so yeah, thank you. I think I wove them into the presentation. If I didn't, feel free to ask and clarify. And as I mentioned earlier, we'll also be in touch with you via email on your specific questions. But yes, you.
So is there a current mailing list that you sign microphones?
Oh, since we're online, we have to wait for the microphone.
Speaking. Who speaks? seem to have already. Is there a mailing list that's available right now so we can sign up for if things as things progress from your satellite office to the downtown office and things will be coming out classes, etc.
So you can email siliconvalley@uspto.gov and ask to be put on the mailing list for events.
There's nothing on the website where you can just sign up on.
No, not yet. There is one that the USPTO has that's agency-wide, that a lot of our events get broadcast that way, and but we don't have it to where you can select specific regions yet. It's something we're working on. But we also have a dedicated Silicon Valley website usually the events that are put on by the USPTO are put on that website. The ones where I participate with a stakeholder organization like this one aren't put on there at this time, but we're working on building those in as well. So whoever has the mic, sorry, okay.
Brian Zonsticker, Power Rocks. Facetiously, I'd ask you, when you list all the cities of the satellite office, you realize Silicon Valley isn't an actual place, right? I mean,
Right.
I'm just scared, for our perception where people really, I mean, it's in San Jose, what a coincidence.
Right.
Anyways, seriously, especially, it sounds great, especially all the resources that you have for, you refer to the independent inventor, or the small fries, I'd say, like me. What's to keep, there are some very deep pockets in this area. So what, have you put in protections in place that keep the people with unlimited pockets and both money, financial and people resources from, just totally stuffing all the channels and like even your fast track thing, right? I mean, for the Googles of the world at a $10,000 per year limit and $4,000, it's almost worth it for them to stuff it with a bunch of junk just simply for competitive purposes, and it costs nothing. So what's to still ensure that a small fry like me can still get my 15 minutes and all the benefits that a small guy does that shouldn't allow for the unfair advantages of the unlimited resource folks that are in this area?
So thank you for the question. I'll just say that currently we're looking at making sure that limit doesn't get exceeded. So if we have to raise, we talked about roughly we might be able to raise the cap, but we're not sure yet. So we're in discussions to see if we get close to the cap, does it make sense for us to raise it? And for particularly, if there is a strategic reason to block the cap, I think that we would be addressing that one way or another internally. That's a good question, and not currently, but it's one I'll raise for sure. Yes.
At what point would I be able to get a one-on-one with the office action attorney?
So with the patent examiner?
Yes.
Yeah, so you can always schedule an interview with the patent examiner. A face-to-face interview is currently only if they're within a commuting distance to either headquarters or regional office. But we are, and through our patent quality initiative, which we actually the comment period extended through the end of this month, I believe, or to the beginning of June. But in the patent quality initiative, we had proposed an option where we could create a mechanism for stakeholders around the country to meet with examiners regardless of where they're located. But if you're looking for an in-person, or are you just looking for it? I mean, otherwise, just pick up the phone and schedule an interview or a WebEx.
No, I'm looking for in-person. I think it's way more valuable. And so since I'm local and the office is local, but is it up to speed yet where it can do that?
No, so the office won't be open, and we'll start hiring examiners into the position. The announcement will go out in the next week or two, and with the expectation that we'll start bringing examiners on board in the fall. So, and then by the end of our first year, we'll have about 80 patent examiners working out of the Silicon Valley space. The chance that they'll be working on your application would still be very rare when you're comparing, 80 examiners to 8,500 examiners working across the country.
I see.
So that's why we tried to beef up our virtual tools, and we have this current proposal on the table to provide other mechanisms for in-person interviews. Who has the mic? Okay.
So to follow up on that question, in order to increase the likelihood that there will be that we can have a in-person interview locally, When your office is fully staffed, will there be a preference for locating examinations of patents filed in California and Silicon Valley to be examined in Silicon Valley, and similarly for petitions filed in Silicon Valley for inter-parties review to have those heard in Silicon Valley?
So it's a very good question, and one we've been grappling with, and it's primarily because it's an economy of scale issue. You know, when you have 25 or 30% of the patents being filed every year from the state of California, and there's 575,000 applications filed last year. Those, if you want to backlog and just leave it for those 80 patent examiners to do, that's going to be a problem. So we've recognized that while that's an ultimate goal for those 80 patent examiners to, we are looking into ways to weight their dockets heavier from cases in the region that are coming out of the region. But then there's a series of questions you have to ask yourself. You know, is it the inventor's location, the attorney's location, the company's location? Where do you? So there's a series of things we need to work through before we make that kind of weighting. Without, the number one priority is, if we were to do that, it's not, we will do it without impacting the first in, first out. Because we don't want to cause any application to be unduly delayed as a result of that manipulating into a satellite region. So that's our biggest concern. And right now we have a very effective mechanism in docketing cases to the examiner based on the oldest cases first. So, and we want to make sure that we're retaining that as well. So, but it's similarly with the trials. Right now with the administrative trials, we'll have about we already have 20 judges on board working with me out of Menlo Park, Patent Trial and Appeal Board judges. We'll hire several more over in the coming months. It'll depend on the trial and where the parties are as to where the location of the trial is. And, but we expect to have many trials through the hearing room. But one thing they've done to ensure consistency across the Patent Trial and Appeal Board is to make sure that no one panel is all from one satellite office. So they will disperse them across. So they have a whole model that they work through. Yes?
John, many of the patents that I've read originate from foreign countries. How does the U.S. Patent Office interact with your neighbors in other countries and vice versa?
So primarily we interact with their U.S. attorneys. And their U.S. attorney serves as a conduit to the applicant overseas or to the applicant's representative overseas. That's most of the time what happens.
So one of the great things about the whole patent prosecution process has been, historically, it's been very transparent. Once a patent's issued, anybody can go in and read the file history and understand what's happened and why it's been issued. And I'm hearing a lot of advocacy from you about the interview process, and my experience has been that oftentimes when you go into a file history and there's been an interview, there's an interview summary, and often it says, an interview occurred. Is that something that's being addressed as you encourage interviews?
Yes, actually with the, I won't go back to it now, but when I listed all of the different training modules that were delivered to examiners, several of them, as a result of the software partnerships that we started about a year and a half ago, we created an 8-phase training module for patent examiners on clarity of record, how to interpret broadest reasonable interpretation, and how to read and address functional claim language. But clarity of record goes to your point with respect to, we've been working with our patent examiners, and we've been providing additional training modules, not just through the Clarity of Record series, but also through interview practice training that we provide to examiners. Every year we provide updated interview practice training, and we are working on building out the clarity of the records, particularly in the interview summaries. And one caveat I'll just throw out there is I was at a conference once, and it was a panel of nothing but litigators, and all the litigators complained that there was nothing in the interview summary about the record. But if as a patent examiner, usually the applicant's representative does not want that detail on the record. So there is this balance that we've been trying to meet. But I think that your point is well taken, and we do want the record to be clear and to really identify what the specific issues are.
So I think the micro entity is great, but many of us have worked in large corporations for decades and may have 4 or more patents in our name, even though we're working as startups now. And many of us may also be supported reluctantly by spouses, have an income that exceeds 3 times the median, especially in Silicon Valley. So it seems like the micro entity is not available to as many people as maybe it should be.
So I know that they wanted to target it for truly the under-resourced inventor, and the pro bono programs that I spoke about earlier, you know, while the micro entity is 3 times the median household, the sum of the pro bono programs are 3 times the poverty level. So it's even a much lower bar, because it's really trying to create programs to help the truly under-resourced inventor. And we all recognize the system is complex and it's expensive, but our goal at the USPTO is to keep our fees as low as we possibly can. Okay. Yes?
So, John, I'm going to put you on the spot a little bit here. I submitted this question online and you did not weave it into your presentation, so I'm going to
okay.
So I'm an expert witness, work as an expert witness and work with law firms on patent litigation. And one of the things that I've noticed is that if you look at the IPR process, of the petitions that are filed, 80% are granted. And of those that are 80% that are brought to litigation or to trial, 80% are granted again, which means that roughly all the patents that are challenged, 2/3 are invalid. What does that say about the USPTO?
I think we're looking at different data. I mean, the data that I've seen is, you know, there might be at least 1 claim in 2/3, but, right, yeah, but the actual, most of the claims are still, you know, sustained. I mean, when you look at, I think it's been there was data, and I don't have the most recent one, data from September or October at the time, which said of, I'm trying to remember the actual number, but I'll just say of like 50,000 claims, only 1,000 were invalidated. It may have been more like 30,000 claims and 1,000 were invalidated. So the number is actually much lower. It just depends on which statistic you want. But when you look on a per claim basis, yeah, it's not the death squad that we've been accused of being in the media. So, not me, the PTAB. We're a separate entity. So,
I'm saying of the claims that are challenged, roughly 2/3 are eventually invalid. Roughly. This is. I may be wrong, but these are the statistics that I've seen.
It's applications, at least 1 claim in 2/3, and I don't even know if the 2/3 number is correct,
right.
But it's at least 1 claim. It's not the, so.
A substantial percentage of challenged claims end up being invalidated. My question is, what does that say about the USPTO? Should you be thinking about changing something?
There's a lot of things that changed. From when that patent was granted, there were Supreme Court decisions which changed, you know, the validity of those claims, in some of them, right? So it really just depends on the case. And you know, there have been cases where, you know, tens of millions of dollars were spent trying to uncover a piece of prior art. So examiners, to the benefit of the system as a whole, you know, are given a finite amount of time, are given, you know, great tools and resources and support to find the best prior art that they can in the amount of time that they have. And that said, those are tools that we continually work to improve, and we're about to roll out even more of them. So we actually just 2 weeks ago rolled out their new examination and docketing system, and then we'll be building more modules on top of that to make that experience even better. Yes, exactly.
Can we ask the next question, please?
John, speaking of Supreme Court decisions, historically the role of the patent examiner is to make prior art rejections. But my question is, to what extent are the examiners being trained in paying more attention to Section 112 issues, especially indefiniteness under the Nautilus ruling, and building a record that helps the applicant on the non-prior art issues?
What's Section 112?
Requires you to, it has different sections, but the one I'm talking about says that if your disclosure, it's not written description, it's indefiniteness under 112.
It's B.
B. If your disclosure, if the scope of the claims is not reasonably certain to a person of skill in the art, in other words, if he can't really tell how much is claimed or not claimed, the patent's invalid.
So with respect to, I'm trying to figure out which answer to answer. With respect to the 4 statutes, right? So, it wasn't just prior art. Examiners have always been trained to not just novelty and obviousness, right? But also the usefulness utility statute 101 and the written description enablement statute 112, right? So, but that was always part of 112, right? So, and the 8-phase training that I mentioned earlier specifically focused, primarily on functional claim language, which was 112F, but also wove in some updates on 112 generally, and with identifying claim scope, clarity for the record, and broadest reasonable interpretation. And broadest reasonable interpretation falls directly with 112B. And with the Nautilus comment, we have not changed our guidelines because it did not really change the way we do our job on a daily basis. So it wasn't a big surprise to us. So where their focus was on the massive change under 101 taking place at the same time.
So we have one last question here.
Thank you.
So I was wondering if first to file in practical terms means that we don't have the 1 year that we used to have to market and publicly test the business model of an idea before actually filing a provisional patent. And I mean, because somebody else may file it while we're actually marketing it, we haven't yet filed it.
You still have the grace period. So the grace period is public disclosure prior to first filing, whether it be provisional or non-provisional.
Right. And what if somebody else, after public disclosure, if somebody else files it in that 1 year period? If you follow a first to file approach, then doesn't that mean that the other person gets the patent?
If they filed it after you, your prior disclosure can be used against it.
I understand.
That's it.
Thank you.
Sure.
I want to thank everybody for coming, and thank you very much, John Quebec.
Thank you.